Good morning. Today I am going to discuss about a very serious case. This case may help for you when you conduct cases of theft, extortion, robbery, dacoity, and collective dacoity or robbery, or not two IPC cases. The most important aspect which you must understand is there is difference between seizure and recovery. Seizure is 102 CRPC being seized under merger. 27 is confession with time gap of information leading to recovery. This is most important. See, this is AR 2023 Supreme Court 3857. AR 2023 Supreme Court 3857 Manoj Kumar Soni vs. State of Madhya Pradesh. Now, complaint was registered by PW18 complaint to the effect that on 14th April 2010 at about 1:30 p.m. while the complainant was in her house, 4 persons rang the doorbell. When her servant PW8 answered the door, all 4 persons armed with pistol forcibly entered the house. They tied up hands and legs of the complainant, and her servant threatened to kill them and proceeded to rob the complainant of silver and gold jewelry, cash and other valuable by taking the keys to the locker. The accused persons remained at the complainant's residence till 2:30 p.m. before fleeing, based upon that 394 IPC registered. The investigation, the specific Manoj or the stolen jewelry allegedly being sold to him, despite being aware that the co-accused has sold him stolen, he still choose to receive and possess the same dishonestly. Consequently, he was arrested. While seized memo dated so bears signature of the seizure witnesses and specific signature other witnesses are there. So, after completion of investigation, charge sheet was filed against the accused Manoj and Kallu. Charges 450, 394, 397 for Kallu 120B IPC and section 411 IPC against that. So, the SLP was against the dismissal of the criminal appeal filed before the High Court. And Manoj sentence under 411. They were convicted by the lower court judgment, and High Court dismissed the appeal. So this is what the case of the prosecution. So what was the ratio? Leave about to go through the judgment entirely. Number first, the accused allegedly being aware that co-accused had sold him stolen goods, received and possessed the same dishonestly and sold them. Even if it was assumed that the items were sold to accused were indeed stolen, it would not be sufficient to attract 411 IPC. So 411 IPC, receiver of stolen property, 414 IPC deals with assisting to dispose the stolen articles. What was further necessary to be proved was continued retention of such article with a dishonest intent and knowledge or belief that items were stolen. This is what conviction set aside. No evidence, no meeting of mind evidence for 120B IPC, no seizure. They say disclosure of statement and recoveries. No evidence except disclosure of statement of accused and co-accused, which led IO to recover stolen articles from accused and cash from co-accused. All four independent seized witnesses were allegedly present during seizure recovery turned hostage. So therefore they have acquitted him. And particularly 313 CRPC questioning was also challenged, argued, and the Supreme Court has said entire case of prosecution was premised on disclosure of statement made by co-accused, but accused was never given opportunity to explain circumstances. Therefore, they say. Then most important is 411 IPC, read with 114A Indian Evidence Act. Presumption of fact under section 114A Evidence Act must be drawn considering other evidence on record, and without corroboration from other cogent evidence. It must not be drawn in isolation. So presumption drawn under section 114A solely relying on disclosure statement made by accused and other co-accused were erroneous. So this is most important. Normally lower court may put your question, what was your explanation under 114A? So for that there may presumption would arise unless and until other cogent evidences are available. So unless and until possession is not proved. So this is case where the Supreme Court has deeply discussed this judgment running lesser page, not too much of pages. It is running from 57 to 68. So some 20 pages. No, it's not 20 pages. 10 pages. So you keep this judgment always on your file. If you are lower court advocate or sessions court advocate conducting trial cases, so whenever if a judge put your question, and this would help you. So then you have to, at the time of cross-examination of investigating officer, you have to specifically say that no such confession was given by the accused, and there was the recovery was artificial, the investigation was table investigation, and since you could not deduct the original criminals, you falsely foisted a case with some animosity or some other motive implicated the accused. You can even suggest that since you have demanded bribe, that he is having jewel shop, and since he is not obliged the request of the police officials, you were waiting for an opportunity and foisted this case. It's a case of the similar nature of the cases is very important. After a very long time, this sort of judgment was delivered. It is delivered on 11/8/2023. So these so many things are discussed at paragraph 25, 26, then 28, 29, 313 question 1, paragraph 32. So these all are most important aspects. Then another aspect was, see, I am not defending, but the immature statement, immature communication by these news agencies. A function was held at Katangulathur about Nandan's birthplace. Some organization conducted a program allowing people from downtrodden community to wear the sacred thread, punur. But they simply jump on saying that since he was presiding the meeting, governor, then just throw murder over. Whatever it may be, I don't think that you may concentrate on such news. But people are misguided, as if governor is interested in politics or other things. These all are programs they are conducting. What nonsense! Everything is going on. Whatever it may be, it is a good day. That was my request was also that if you want to resist this, whatever the objectionable area of Sanadana discipline, you be in Hindu and try to eradicate by your ideological revolutions. That's what I say. Instead of allowing the downtrodden people having names in a different style, give them a name at par with other higher community, and so at least at the school college level the children may think different presumption about the caste and the background of the all that you have to concentrate. It is up to you to decide. But so far I am concerned in my area where downtrodden people are there, they are having a good name at par with the other higher community. Best wishes.